All right, good afternoon, ladies and gentlemen. Name is Dwight Tukits. I'll be moderating this session. We are way behind in terms of time, so we're going to get rolling. We're going to invite the PPC to make their presentation, and I'm going to call to the mic Mrs. Erica James King.
So I know we have had a long day, so I'm going to be brief, just sensitizing you on who or what the PPC is. And then I'm going to turn over to a colleague of mine, Mr. Juno, Welton Juno, who is the contractor evaluation manager with the PPC to talk a little bit about the contractor and consultant performance evaluation program, CPEP, which affects persons in the construction industry and in other sectors of the economy. All right, so the PPC regard us as your partner. If you're in business, whether it is relevant to construction or not, goods or relevant to goods and services, then we are your partner for income generation. If you want to do business with government, then the PPC is your first port of call. And we have several services. Some you may not be familiar with, some you may be familiar with. But let me go through as quickly as possible. Now, the Public Procurement Commission, PPC, was given birth to by the Public Procurement Act 2015. And as part of the legislation, we are actually named in the Act, Section 9, I think it's 1-9 of the Act, that we are named as the entity which is to give, well, to examine and to give oversight to the public procurement processes in Jamaica. And you may ask, what is public procurement? If you don't know as yet, which I hope you do, but we have students, tertiary students here too. So public procurement is about procuring or acquiring goods, works, and services using state funds. And of course, state funds is whose funds? Whose funds? Our funds, taxpayers' money. So it's about using state funds to acquire goods, works, or services. And so the PPC is the guardian of that process in Jamaica. We are there to see to it that state funds are used in an effective and efficient manner. And so our mandate is about ensuring value for money, efficiency, integrity, and transparency in the public procurement process. Now, our vision, you may see it on the screen there, is to develop a world-leading public procurement body that boosts business confidence and enables growth and national development. Now, I'm going to let you read the mission. I will go through quickly. So this is about what we do. Our core business is about public procurement systems, and that often deals with supplier registration. That has to do with much of the contractors and suppliers in other sectors of the economy. It's about contract approval, because our stakeholders are not just private sector, but they're also public sector entities. So the over 194 ministries, departments, and agencies of government are also our stakeholders because they come to us to have their procurement submissions reviewed or approved and get feedback on it. So we may approve it, we may send it back, and we also make recommendations to cabinet on what is to be approved. I already touched on our mandate, and that is prescribed in the Public Procurement Act 2015, Section 10. Among our functions, approving and endorsing the award of procurement contracts, we register and classify persons, firms, or entities as suppliers, and approve persons, firms, or entities. And as contractors, you know, there are several categories of contractors now in the system, and PPC, depending on several criteria where you fall, you may be in grade 1 or 2 or 3 category. Other functions there ensure prudence in the use of public funds. So the supplier registration system, PPC, is the home to that software, to that portal, and it is the way in which contractors or suppliers, I prefer to use the word suppliers, register to do business with government. So it's an online portal, and it was established in May 2021 during COVID. So no longer you have to be carrying documents and reams of them to us at PPC at Knoxford Boulevard, but you can stay anywhere at do this registration at any time on any day. If you're relaxing on the beach, or if it is Christmas Day or it's your birthday, doesn't matter. You can register with the PPC using the supplier registration system. And this sits on the GoJEP platform. So you may or may not be aware of that. We have a booth. You can get familiar. You can even start your registration process outside here. So just to remind you, if you don't know, well, if you know already, and if you don't know, then you ought to get familiar with the supplier registration system. Just to say that governments all over the world have to engage in public procurement. So it's income generation, and it's big business, it's $1 billion business. And it means, therefore, that, well, in Jamaica alone, over 30% of our gross domestic product goes towards public procurement. So if you're not tapping into doing business with government, then you're losing out on what you could do to boost your business. Well, I went through this already. So it's the GoJEP platform, which is gojep.gov.jm. These are some of our promotional material on the GoJEP system, or supply registration system. PPC is also the home to the contractor and consultant performance evaluation program that was launched in 2023 November. And Mr. Welton Jr. will go into this, but just to say, this is aimed at ensuring quality performance on procurements and procurement projects. So taxpayers' dollar value, we're trying to ensure through this other program, which requires a collaboration between the public sector and the private sector, because ministries, departments, and agencies of government, or the procuring entities, as we call them, ought to evaluate contractors who they employ or engage in contracts. And there's a criteria. So this system has put in place a standard or uniform list of criteria that are used to evaluate contractors and consultants. And I will skip over some of this because Mr. Junior will go into that. It was launched by our former finance minister, Dr. Nigel Clark, in November 2023. PPC is also home to PEDMS, another software which is the procurement endorsement database management system, PEDMS. And this is specifically tailored to our public sector entities. So when they send us procurement submissions, these are done via this software. They are submitted through the software. This is not taken manually or by email, but it has to be done through the software. And they can track in real time the review of these submissions. And this software has reduced the processing time to an average of 2 weeks to process procurement submissions from the public sector entities. So you see, PPC is trying to give you value for your money, and also efficiency and transparency by adding the software to make things easier for all our stakeholders. These are just some stakeholder engagements as part of our activities. We reach out to our stakeholders from time to time. This, I think, was the Expo Jamaica at one point, where we engage with others in the sector. And our stakeholders also include not just Jamaicans. This was the Trinidad and Tobago Commerce, Chamber of Commerce. We have engaged them, as well as we have also recently engaged the Trinidad and Tobago Manufacturers Association, trying to give them, well, tell them what we have to offer and see how we could collaborate with them and encourage more trade within the region. Other of our engagements. Now, this was our financial year just ended, where PPC actually reviewed, and I want you to look at the figure in the to the left, 154 billion 635,324,477 and 21 cents. That is the value of the procurement submissions that were reviewed by PPC. Now, I hope you had some contractual arrangements in there, else you're missing out. And I'm sure this financial year, it will be bigger. Just to see though that works comprise the bulk of that pie of public procurement reviews done by the PPC, you actually comprise 49.5%. And next in line would be services. So there is money to be gained, and we just have to register, and we try to work out some of the kinks as well that may be affecting the public procurement process. Recently, there was some amendments to that, but at a later date, we could go into that since we have no time now. So no matter what it is you're doing, the PPC can facilitate you, can be your partner in helping you to register at any time, any day, and from anywhere. Just want to say also that we pride ourselves in being responsive to our stakeholders, and this was our last customer satisfaction survey, and this is generally done independently. And if you see the blue line there, it means 86% of our customers are satisfied with us. The dissatisfied is just the red section there. So the satisfaction adds up to what? That's 6 and 2, 8, 98% satisfaction level if you add satisfied and very satisfied. And so just 2% dissatisfied. But we take your feedback and we work on them seriously. Now, I just want to say, well, through social media, please follow us too. And if you have any feedback, you can give us not just in person, but you can give us on our social media platforms. And our followers not only include Jamaicans, but others in the region and the Caribbean. Now, I just want to introduce Mr. Juna, who will tell you more about the contractor and Consultant Performance Evaluation Program, CPEP. Mr. Juna is the evaluation manager with the PPC, and he's a project management consultant as well as a technical vocational education practitioner, and he has been with the PPC for over 2 years. Put your hands together and welcome Mr. Juna at this time.
A part of my presentation includes sanctions. And when the public hears sanctions, that is the time when a person seems more alive. How are we doing today after lunch? Everybody okay? All right, so I don't want you to be afraid when you hear the word sanctions because it is something good and something not so good, right? And I also want to encourage you. I haven't heard any encouragement from morning as yet. Dwayne Bailey, procurement specialist in the Gleaner on the 9th of December 2025, sorry, 2024, would have put forward stop being afraid of doing business with the government. And I am encouraging you to that it is billions of dollars, trillions of dollars that is all set aside to do business with government. Also, we are targeting the micro, small, and medium enterprises. Mr. Bennett would have put forward in the Gleaner as well, encouraging entrepreneurs, young entrepreneurs. I saw some persons earlier from art, encouraging you to get familiar with the processes that Ms. James King would have put forward, as in to register through our systems and get on board to do business with government. Now, as we speak about procurement from morning, we have been talking about procurement, we spoke about tendering, we talk about the drawing, specification, contracting, and also contract development. What I'm going to talk to you about this evening is more about contract management, nothing to do much about procuring. So 90% of the process entails the procurement process, where you would have identified the ministries, departments, and agencies would have identified a need. They have developed workflow. They have submitted their bidding documentations to the public. You, the suppliers, the contractors and consultants, would have moved forward to completing the bidding process and winning your contracts. Now, the other 10% has to do with contract management, and that is where my department comes in, contract management, the contractor and consultant performance evaluation program. So we spoke about procurement this morning. We spoke about the contracting process. Now, I just want to highlight who are our contractors and who are our consultants as it relates to the policy. The policy adopts an interpretation of the term contractor as set out in the Act, which means a bidder to whom a procurement contract has been awarded by the procuring entity. Now, consultants means a contractor who who provides consulting services in accordance with definition thereof as set out in the Act. Now, what is CPEP? Contractor and Consultant Performance Evaluation Program, CPEP, is a comprehensive initiative designed to enhance the effectiveness and efficiency of public procurement in Jamaica. It's a collaborative effort with the Public Procurement Commission, the ministries, departments, and agencies, and you, the suppliers, the contractors, and consultants. As Ms. James King would have put forward before coming up here, the policy was approved by Cabinet in February of 2023. It was launched November 15, 2023. December 11th, 2023, the Ministry of Finance and Public Service would have issued to the ministries, departments, and agencies to implement the CPEP in their space. They've also provided the documents such as the policy itself, Circular 32, and a guidance note which provides a procedure as how to implement the policy and the program within the ministries, departments, and agencies. Now, the system has 4 components. It starts out with a policy, as I mentioned before, which provides guidance, consistency, accountability, and clarity as it relates to business activity. The program is set out with basically provide direction with the goals, procedures, and plans as how we will operate. Then we have the DVBI portal, Data Visualization and Business Intelligence Portal. It's a national database that basically records all the the contractors and consultants' performance evaluations. And we have you, the consultants, the contractors, in line with the Public Procurement Commission and the ministries, departments, and agency as the stakeholders. Quickly, we look at the objectives. And one of the main objectives that I like to talk about when I'm presenting is the value for money. Now, you would have seen already on the website, social media, and so forth that Black Friday is out. Many of us will have items in our basket. Who don't have any items in their basket as yet? Well, you still have time. We have until Friday. Now, I mentioned Black Friday because of value for money. When I am getting goods and services from the market, I seek to get value for money. Anybody else who does that? Sure thing, right? Right. And it is important because money doesn't come easy these days. So you yourself as individuals in your domestic space would have tried to achieve value for money when you were spending. And it is the same thing when it comes to spending government money. Accounting officers in the ministries, departments, and agencies have that responsibility to ensure that they achieve value for money. And it's the same thing that we're trying to achieve. One of the main things that we're trying to achieve with this policy, to achieve value for money in the implementation of procurement contracts. The next objective speaks to the capacity of procuring entities to fairly and equitably assess performance of contractors and maintain the scores. Also to improve the performance and the capacity of contractors. So you would have heard me mention before sanctions, and it's not to throw you out of market, because if it is that we throw or get rid of persons who are not doing so well, contractors and consultants that are not doing so well, then that basically can mash up the market. Jamaica won't have anybody to do business with. True or false? Right. So we have programs in place where we try to improve those persons who are not doing so well, the contractors and consultants, also with the ministries, departments, or agencies to get everybody up to par. Recently, we would have had a Meet the Buyer symposium with the National Head Fund, where we allowed them to invite their stakeholders, their suppliers in, and we discussed the challenges that we have. We discussed the new laws that we have in front of us and how we can make the procurement system better on their side. Also, another objective is to foster positive supplier and contractor relationship in procurement. Now we get more closer to business. As it relates to the CPEP policy, the mandatory performance evaluation threshold is $10 million. So we are now looking at any contracts that have been approved. We are doing the performance evaluation for those contracts that are $10 million and more. But there are some exceptions. Where you have a contract that is being terminated or canceled, regardless of the value, those contracts have to be reported. Also, those contracts that have been awarded to micro, small, and medium-sized businesses under the Government of Jamaica policy for special and differential treatment, these contracts have to be reported into the system as well. You would have noticed that Hurricane Melissa would have passed, and we now have numerous amounts of emergencies all over the island. These contracts have to be reported into the system as well. So now we look at examples when do we perform a performance evaluation. First up, where a consultant or a contractor has been contracted to supply goods, services, and work under the contract or a purchase order. Number two, where the contract has supplied goods, services, and works as a joint venture, a report must be conducted for the joint venture as well. Number three, where the prime contractor has appointed a subcontractor, then the prime contractor will be evaluated based on how they manage their subcontractors. If a contractor is substituted, a report must be done for the outgoing contractor, also the incoming contractor. Now, this morning, other presenters would have mentioned documentation that you must, or you should, or you may maintain in your space while you're executing your contracts. And it's the same goes for the CPEP policy. We are suggesting that you maintain documentations that look at your operation monitors, such as progress reports, performance reports, project operational manuals, calendar monitors, such as your master schedule, project milestone Gantt charts, manufacturer production schedule, financial monitors like your budget, your cost control reports, your conditions for payment and payment adjustment provisions. Also, risk monitors that speak to your shipping arrangements, insurance documents and arrangements, national disaster plans, just to name a few. So you need to maintain these documentations in order to support your claim with the CPEP system. I'll quickly look at the types of reports that the system allows and the frequency, starting with the interim evaluation report. The interim evaluation report is done periodically during the life of the contract. And then you have the final report, which is conducted at the end of the contract. An addendum report is done, for example, you have done a interim or final report, and you need to amend. The addendum report will allow you to do so. Special evaluation reporting allow you to make reports where you find a special situation. For example, defects liability, you can use your special evaluation report to supplement. Now we look at the duration in which you do these reports. For a contract that lasts less than a month or a month, then you only need the final report, no interims. For contracts that last 1 to 4 months, you need one final report and one interim. When it comes to 4 to 8 months, two interim reports and a final. 8 to 12 months, you need three interims and a final. When it comes to contracts that last over 12 months, you need four interim reports. An interim report every 4 months until that contract comes to an end. Now we get into performance evaluation indicator. How is it that the performance evaluation is done? What is the performance evaluation? Performance evaluation focus on what particular contract has been achieved, how it is being implemented, how it is perceived and valued, whether expected results are occurring, or questions that are pertinent to the contract design, management, and operational decisions. Now we look at the evaluation matrix of the contractor performance evaluation. Now, if you look to your left, you will see a table putting forward the criterion and description. The criterions include administration, safety, quality, execution, and cost control for contractors. For consultants, the criterions include the administration, execution, and staffing. Now, this is an example. We are looking at administration as to how the matrix works. So administration speaks to the extent of which the contractor's responsiveness, timeliness, and communication and reporting during the execution of the contract. Now, the second row speaks to the performance grading, which spans from 1 to 10. Then the third row look at the indicator description. The indicator description would be, for example, the delivery of laptops on screen, and the span to which the evaluations are done starts from unsatisfactory, needs improvement, acceptable, requirements fully met, exceeds requirements. And the example now with the laptop situation could be more than 7 months, 6 to 7 months, 4 to 5 months, 3 months, or less than 3 months. This is just an example for the administration as how it looks like. Now, the next slide is the actual evaluation on the DVBI system. This is what the system looks like. And I must make mention who are the persons who will set up the evaluations on the system. The ministry departments and agencies will appoint assessors, and these are the persons who will execute the evaluation for each contractor and consultant for each contracts that they will engage. This is another example of the full view of the evaluation matrix. And the scoring mechanism starts from 80% to 30%, where 80% scoring is deemed to be an excellent contractor, and below 30 is deemed to be unsatisfactory. This is an example of the scorecard. This is what it looks like. When the evaluation is concluded, each contractor or consultant will get their scorecard, and this is what it looks like. For this person, it's a deficient performer, but not all persons are like this. So when you receive your contracts, when you win your contracts, before signing the contract, procuring entities must collaborate with the contractor to ensure that the necessary matrix is being discussed, and after signing those contracts, before signing those contracts, the matrix is also signed and append to the contract as well. This is a view of the digital visualization and business intelligence portal. And this is what the contractors and consultants view will look like. I want to speak quickly about conflict management. If it is that the contractor refute their score, it goes back to the assessor. If it is that the assessor can't manage the, the review, then it moves on to the procurement committee. If not, then it moves on to the head of entity and then to the PPC Board of Commissioners for final review. And then sanctions. This is where I will end. If it is that a contractor has received a final score calculated in accordance with the policy that is less than 50%, then the contractor will receive a warning from the procuring entity. Two, a contractor or consultant receiving 3 warnings in a given fiscal year may be suspended from the supplier's register in respect of the category or categories of registration applicable to the contract in which the poor performance was recorded. And 3, a contractor or consultant receiving at least 2 suspensions in a given fiscal year may be expelled from the supplier's register in respect of the category of registration. Also, where the contractor or consultant are registered with a professional body, then the professional bodies such as the Professional Engineers Registration Board or Architect Board will be informed of these decisions as well. The information is provided to other external entities such as the Integrity Commission, the European Union, and other entities, just to mention a few. And that is where I will stop today. Thank you very much.
Thank the PPC for their presentation. And we're going to move straight ahead into the other 2 presenters. I've gotten their permission for us not to do the bio. So we're just going to move straight into the act. So first on board will be, I'm not sure the title, um, Dean Burrows, quantity surveyor, arbitrator, and he'll be dealing with bonds, guarantees, insurance, and arbitration. Welcome, Mr. Burrows.
It's essential that stakeholders remain fully aware of the potential risks as well as the contractual and legal obligations that arise when these risks arise. I'm speaking about risks that arise not only from hearing what the PPCCPP had to say a while ago, but also risks like Hurricane Melissa. And therefore, parties engaged in the built environment must safeguard themselves through instruments designed to mitigate or offset the financial consequences of adverse effects. The primary instruments available to construction participants for risk management are bonds, guarantees, and insurance policy. And I go straight to the standard form of contracts that are there because they include protocols to minimize or avoid pitfalls or loss or damage to the contractors and to the employers. The first one is the Construction Industry Council standard form of building contract. That's a CIC contract. And it stipulates insurance requirements under clauses 18, 19, and 20, unless the employer elects to bear the cost of insurance. Under clause 20B, the contractor must indemnify the employer. The next one is the agreement for minor works. And earlier I heard that some people didn't know what the agreement for minor works was. But the agreement for minor works deals with contracts up to $20 million. Twice the figure that was quoted. And in that, they cover insurances under clause 6. Now the FIDIC contract, and I'm speaking of the FIDIC Red Book here, that's the FIDIC conditions of contract for construction. Under clause 18 requires the contractor to insure the works, equipment, and the personnel. However, that insurance is subject to the employer's approval of the insurer and the policy terms. Be careful about that one. In all cases, if the contractor fails to provide evidence of insurance, the employer may procure the necessary coverage and recover the costs, deducting it from sums due to the contractor. So we have an overview of what insurances and bonds look like. But let's dig deep into bonds. A construction bond is a formal agreement in which a surety, that's a guarantor, a guarantee that the contractor will fulfill his contractual obligations to the employer. Should the contractor default, the surety must either perform the obligations or cover the employer's completion cost. Either perform the obligation or cover the cost to complete. In return for this guarantee, the contractor pays the surety a fee or a premium, and it may be required to, and the contractor may be required to pledge assets as collateral. A guarantee, on the other hand, is an accessory contract, not accurate, an accessory contract by which the promisor, the surety, undertakes to be answerable to the promisee for the debt, default, or miscarriage of another person, whose primary liability is to the promisee. Now, it is a guarantor's responsibility to ensure that the employer is compensated if the contractor fails. Not only in such circumstances does the guarantor become liable for damages to the beneficiary. Importantly, a guarantee or bond must be in writing and executed by the guarantor or bondsman. Without a signed written agreement, no claim can be made against the guarantor. Now, I want to look at bonds versus insurance policy. Although both bonds and insurance policies are risk management tools, they differ significantly. One, the parties involved are important. A construction bond is a three-party agreement between the surety, the contractor, and the employer. An insurance policy is a two-party agreement between the insurer and the insured. Now, there are events that trigger both. The bond is triggered when the contractor defaults on obligations to the employer, unless the default results from the employer's own actions, such as insolvency, bankruptcy, or he abandons the work. The insurance coverage, on the other hand, is triggered only by accidental events. And those accidental events are specified, named in the policy. The nature of the loss. A bond covers pure economic loss, and we get into economics here. And the economic loss is the cost of completing the contractor's obligation, even if no physical damage occurs. Insurance, on the other hand, yes, I'm going to show you when I'm going through. I'm going to show you at the end. I pointed that out. Yes. On the other hand, insurance covers physical loss or damage to works. So the bond covers pure economic loss. The insurance covers physical loss or damage to the works, in the materials, or to the personnel. Liability and property insurance do not cover defective or incomplete work. They only cover expenses arising from actual damage. And the right of recovery on a bond. A surety that pays out under a bond may pursue legal action against the defaulting contractor to recover costs. So if the bond, the surety defaults, the surety pays out, he can go to the contractor and hold on to the collateral, or sue him. The insurer, on the other hand, that pays out under a policy has no right of recovery against the insured. Types of construction bonds. First one that we deal with, and we spoke about it earlier, they are bid bonds, or what is called a tender bond. It's required, a bid bond is required to ensure that a contractor honors their bond, their bid. If the contractor refuses to proceed under the bid terms, the surety compensates the employer for the difference between the dishonored bid and the next lowest bid. I want to be clear of that. Up to the bid bond limit. So if the contractor refuses to proceed under the bid terms, the surety compensates the employer for the difference between the dishonored bid and the next lowest bid, up to the bid limit. These bonds typically include a time limit for enforceability, so you can't just sit there and wait. You have a time within which to bring this forward. A performance bond, on the other hand, guarantees that the contractor will fulfill all contractual obligations. If the contractor defaults, the surety either completes the work or pays the employer the cost of completion up to the bond limit. Case law clarifies that default refers to serious breaches, warnings, warranting a formal warning or what is called a formal notice under contract. Even if the employer does not intend to claim immediately, contractors should be notified of significant issues that come up to prevent disputes over future claims. So if a contractor defaults, it might not be serious. You must still give them a warning because it has implications down the road. There are advance payment bonds or what is called mobilization bonds. These bonds are used when the employer provides advance payment for materials or mobilization. If the contract fails to secure the goods or material, the bonds offset the employer's loss. Another bond is the off-site material bond. The off-site material bond is similar to the advance payment bond or the mobilization bond. It applies when the contractor stores materials off-site that have been already paid for by the employer. So if you include if the quantity surveyor includes in the certificate for material that's held off-site, the contractor should or may be required to put a bond on it to take care. It ensures that the employer's investment in those materials is protected should the contractor fail to deliver the materials to site. Then the defects liability bond, and I hear people talking about defects liability, but you can have a defects liability bond. Sometimes half of the retention is held, but instead of that, you could go for a defects liability bond. And this defects liability bond is required to safeguard against defects identified during the defects liability period. If the contractor fails to remedy defects, the bond can be called upon to compensate the employer. And then there's another bond called the adjudication bond. The adjudication bond provides security in the event of a dispute referred to adjudication. Adjudication is a dispute, resolving the dispute while the contract is going. And I'm supposed to be speaking about arbitration. The difference between adjudication and arbitration. Adjudication can occur while the work is going on, but arbitration can only commence at the end of the work. The adjudication bond guarantees that the adjudicator's decision will be honored by the parties. Bonds can be generally classified into two classifications. What is called on-demand bonds, which entitle the employer to demand payment from the bondsman, issuing a notice in a prescribed form. And payment on this on-demand bond must be made regardless of disputes about the underlying contract or the reason for calling the bond. The next we can have conditional bonds. And a conditional bond requires the employer to actually establish that loss has occurred. And this type of bond is more akin to a guarantee. Now, the next one I'll go on to is insurances. Now, the insurances, I remember I told you the difference between a bond and an insurance. One is a three-party agreement and one is a two-party agreement. Insurance is a financial mechanism by which a party pays premiums in exchange for protection against potential risk. It functions as a safety net. And what can happen here is that the parties or the contractor can do what is called a risk assessment. And what the risk assessment does is really look at the likely risks, its cause, and its consequences. Now, when we're speaking about construction, insurance under construction indemnifies against financial losses by covering damage to the works, injury to persons, property damage, and professional negligence. The main types of insurance in construction is the main types, and I want to listen carefully, is contractors' all risk insurance, which covers ongoing works, materials on or off the site, equipment, and injury to persons during the contract period. It's taken out jointly in the names, typically in the names of both the contractor and the employer. It covers natural risk, such as force majeure, and accidental risk. Claims require evidence, and we spoke about evidence earlier, detailed records of cause, timing, and effect. These are critical in claiming against contractors' all risks. Then we have public liability insurance. Public liability insurance protects against liability for injury or damage to third parties or property not connected with the works. Therefore, if you are walking past the building and there's the conference center, and while construction is going on and something hits you, you can claim, the contractor can be asked to pay public liability insurance. It excludes intentional acts. So if somebody on the site take up a stone and throw and hit you intentionally, that the contractor will not be liable for public liability insurance. Employers' liability insurance is the next one. It protects against liability for injury or death of employers arising from their employment. And other relevant insurances come up, like professional indemnity insurance, product liability insurance, and property insurance. Now, I just want to look at a few of the insurances. Employers' liability insurance covers claims arising from injury or death of employers while they are carrying out the works. These obligations stem from the contractor's duty to provide a safe working environment. And as I pointed out, injuries may result from accident or negligence, and coverage typically includes medical expenses, lost wages, and compensation for property damage. Now, The government has in place what is called a workers' compensation scheme, and they tell you the limit within which it is thing. But under this legislation, the schemes provide automatic compensation up to a particular level, and then the contractor's public liability, the employer's liability takes on over that. I want also to mention professional indemnity insurance. It protects consultants, designers, and other professionals against claims arising from negligence, faulty advice, or substandard service that cause financial loss to their clients. In Jamaica, we are sort of averse against enforcing this one. Many professional bodies require that their members maintain indemnity insurance. Liability may extend beyond the individual to the professional practice or to the companies. And some clients insist that professionals engaged on projects carry out this insurance. Professional indemnity insurance compensates clients for actual economic loss. Now, I want to just say, and I'm taking a little time out here, because I know the Building Act allows for, and I might be a little controversial, allows for persons to design buildings up to a minimum size. But you need to understand that if you are not capable, professionally able to handle the liability that can result from you doing that sort of work, you must be careful. Because it's the economic loss that you will have to pay if somebody pulls you up. And I hear also people talking about, while I was talking, there were folks speaking about, this agency is not getting good professional service and that good professional service. You are going to be held equivalent to your peers. So if you go there and practice as an architect and you are a draftsman and the client suffers loss, you are likely to have to pay the economic loss. Similar for engineers, similar for quantity surveyors. And a lot of persons do take on these things without realizing the implications of what is hanging over their heads. Product liability insurance is insurance which covers manufacturers and suppliers against claims for injuries or damages caused by defective or dangerous products. So people who offer a particular product and you get manufacturers offering products, they ought to give you, they take on some responsibility that the product that they are giving you, it doesn't harm you. Property insurance, and this is not one that falls under contractors, building contractors as much, but I think I need to do that in light of what is happening today and Melissa just going on. Property insurance protects the owners against loss or damage caused by risks named in the policy, such as hurricane or fire or flood, or sometimes it's covered under the term force majeure. Some of the causes may be optional, like you might be asked to put in flood insurance separately or fire insurance separately. The key figures on the property property insurance, the key figures are exclusions. There's certain risks such as flood may be excluded. There's also the average clause, and payouts are prorated based on the ratio of the insured sum to the property current value, requiring owners to keep their valuations up to date. And there's also what is called a deductible or an excess. Claims are payable only after the insured covers the agreed excesses. Policyholders must be aware of hazards and ensure adequate coverage. For example, where there's a flood likely, they should carry the mandatory flood insurance. Sometimes your mortgage will include that as an addendum, that if you're buying a house here, beware, it's likely to flood, and take out flood insurance. For those who are taking on and doing assessments on the property insurance this week or next week or in the following months, remember that property insurance, when you put in a claim, it restores the property to the pre-loss condition. It is not an insurance that restores a property to an improved state. Therefore, if you had corrugated zinc, you do not put in a claim for standing seam. Claimants must demonstrate reasonable steps to mitigate the damage. So you can't see somebody going down and say, boy, I never do anything. If it can be proved that you didn't make any effort to protect the place, it can be held against you. The court may deny further loss if the loss occurred is due to negligence in preventing avoidable damage. And I go on now, having looked at insurances and bonds, I go into arbitration, because arbitration is not as not one of those instruments that we spoke about, risk instruments, but in a sense it does, because arbitration is in most cases a final and binding procedure for resolving disputes. There are other procedures for resolving disputes, and for those who use the CIC contracts or the FIDIC contracts, on the CIC contracts you'll find the mediation, adjudication, and arbitration. Under the FIDIC contract, you have what is called a dispute resolution board, and then you go to adjudication and arbitration. Arbitration is defined by Mr. Walker, professor, as the adjudication of a dispute or controversy on fact or law or both outside the ordinary civil courts by one or more persons to whom the parties in issue refer to the matter for a decision. In Jamaica, we have what is called an Arbitration Act. The Jamaica Arbitration Act of 2017 provides a framework for resolving disputes in both domestic and international matters. It may be applied subject to agreements between Jamaica and Jamaicans and other persons in Jamaica, or persons in Jamaica and persons outside of Jamaica. Parties anticipating disputes may include what is called an arbitration clause in their contract, which allows them to go to arbitration. The arbitration agreement within the dispute typically sets out the size of the tribunal, the method of selecting arbiters, the seat of the arbitration, and the laws governing the arbitration. Arbitration is a consensual process. Both parties must agree. So if you want to go to arbitration and the contractor don't want to go to arbitration, you can't go to arbitration. Arbitration's decision can be binding. It's as binding as a high court decision. Arbitration, however, is flexible. Unlike judicial proceedings, which is very formal, arbitration is flexible. So it allows the party to tailor the dispute, and if they want, they can hold the dispute in privacy. If you have trade secrets and you don't want anybody to know, go to arbitration. Because if you go to court, court is a public space and anybody can come in and listen to you. So arbitration is confidential. Arbitration differs from court proceedings in that not only it can be flexible and confidential, the speed of determination under arbitration is a lot faster. See, when you go to court and the lawyer comes in and he says, "I'm not ready, my lord." Lord says, "When can I put you in my date, my book?" And he goes, "No, I'm not available for the next 3 months." That's not quite arbitration. It's a lot faster. The arbitration allows for procedural laws. The parties can agree on the rules. The choice of the arbitrator is between the two parties, and the arbitration deals also allows for international enforcement under the Arbitration Act of the New York Convention Arbitration Act. So if you have a case in arbitration and you want to enforce it in New York, it is enforceable. Not quite as easy with the courts. We spoke about the forms of contract, the bonds, the types of bonds and insurances, the types of insurances, and then we went on to arbitration. So we indicated that the forms of contract, there were 3 forms of contract: the standard form of building contract, the agreement for minor works, and the FIDIC contract, and the clauses under which they fall: clause 18, 19, and 20 for the standard form, and for the minor works, clause 6, where 6.1, 6.2, 6.3a, and 6.3b, and 6.4, and for the FIDIC contracts, it's clause 18. I told you about bonds, and it's an agreement which is a surety undertakes to pay the completion costs or undertakes the obligation to the employer. And I told you about the types of bond: the bid bond or tender bond, the performance bond, the advance bond or mobilization bond, the off-site material bond, the defects liability bond, and the adjudication bond. Those are the types of bonds. And then I went on to insurances. And then I told you about the contractor's all risk insurance, the public liability insurance, the employer's liability insurance, the professional liability insurance, and I gave a little warning for those professionals who are professionals but they are not quite sure, and the product liability insurance. Now I say, you know, why I say this, and I know the chuckle, because I know that the first time a person gets called up under professional liability insurance, somebody can say, boy, man, unlucky. And what I'm saying is that we just make sure it's not you. Economic loss is not a light thing to carry. Then I went into arbitration. The three main types of insurances required by building contractors. I went into that. Then I went into arbitration, is the adjudication of disputes or controversy in fact or law, or both outside the ordinary civil courts by one or more persons, to whom the parties who have an issue refer the matter for this decision. And I told you that the Jamaica Arbitration Act of 2017 provides this protocol by which we do. And then I pointed out the advantages of arbitration: confidentiality, speed of determination, choice of procedural laws, choice of decision maker, and enforceability. And you would probably ask me, has there been any arbitration in Jamaica? Oh, yes. Oh, yes. When the highway was being built, there was an arbitration case. The contractor didn't agree with NROC, and the seat of arbitration, however, was not in Jamaica. And I always wring my hands when I realize it, because possibly, if we understand the gravity of some of these things and the tools that we have, we will grasp and we'll take better care to ensure that they are handled correctly. I think the seat of arbitration in the Jamaican case was in Japan. And when the seat of arbitration is there, it puts the Jamaican at a big loss. I want to thank you. Are there any questions?
Under a construction bond, who are the entities or the persons who would act as a surety?
The surety is the financial body. So you go to the surety and you say, listen, I have a contract, and the client or the employer says, I need a bond. And the surety says, if you pay me so much dollars, I will take a look at your track record, the contractor, and some contractors are here. But although you're a good contractor, still want to hold on to your house title. I will give you the bond so you can build. But now listen, if you default, I will finish up the work for you, or I will pay the difference, but your house gone. So you understand who the surety is now? The financial organization. Yes. Insurance companies do it, some banks do it, but mainly insurance companies.
Does there exist a register of the decisions of arbitrators, like especially for government related arbitrations?
Oh, they can if they want. They can if they so choose. But because it carries with it this flexibility, there are many persons who prefer to keep that out of the limelight. But I presume public pressure may convince them to come forward and say what occurred, because I don't know that a lot of persons know about the highways and that arbitration. Right. So confidentiality is one of the hallmarks of arbitration. If you are in the manufacturing business, and if you're in CC, I keep on forgetting the public procurement gentleman who presented here before, and you have a contract with, and you reported it to them, they can't take your trade secret and divulge it to somebody else. If you go to arbitration, you can ask that it be kept secret, because the colonel's recipe, what's in the colonel's recipe? The chicken that people line up to get all the time. If you're going to an arbitration, you can't ask the colonel to tell you what his recipe is. Is that all right? Thank you very much.
I'd like to invite to the podium Mr. Donald Moore, Engineer Donald Moore, who will do a presentation regarding the PPC has left. This word, some people refer to it as a bad word. Variations. time extension, damages, and fluctuations. So these are not usually good terms to refer in the public domain. But Mr. Moore, Engineer Moore, will guide us through and give us a better explanation regarding the subject matter.
We talk a lot about value for money, right? When Minister Morgan spoke this morning, he spoke about the need for the contracts to be clear, fair, and well managed, right? That to me becomes the essence of a lot of what occurs in contracts. The time and cost of the contract must be reasonable. If it's not reasonable, you're going to have problems from the very start. I think Andrew identified two most important issues for successful projects for all parties. One, understand the contract. If you don't understand it, you're in trouble. And the second one, which is what I suppose a lot of people are talking about as we went along discussing whether it is a PPC or otherwise, is the discipline of the parties involved. We tend to have a lot of indiscipline involved. This is Jamaica, and I suspect that it is part and parcel of the same thing. It is true, but it is true. The FIDIC 2017 came about for several reasons. One is that I think Jacqueline earlier said that 90% of the court cases for construction contracts were about delays. And I read somewhere that over 90% of construction contracts are delayed. So there is something between all of that. Now, FIDIC must be very well aware of this as well. And so part of what FIDIC attempted to do in the 2017 document is actually to fix some of the project management issues, right? So even though what we'll be talking about, what I'll be going into in a little detail, I won't keep you long, know that you want to go home, is the 1999 edition, right? That is what we'll be talking about because this is what we are using for most of our construction projects. And therefore, that is what we need to be fully au fait with. But I suspect that within another 3 to 5 years, we will be migrating over to the 2017 document, primarily because of some of the changes that are in it. Now, a lot of the issues, again, has to do with communication, the way things are interpreted and so on. And therefore, they try to become more prescriptive in the 2017 documents. I'll just run through very quickly some changes made. Claims and disputes, the process has become more prescriptive. Engineer's determination, the engineer's determination is binding, and you can issue your notice of dissatisfaction and go to your DAB, which is now required to be put in place. Claims are required to be fully detailed, and they have actually stated what detail means. So it's not just to say the thing must be reasonable or and so it must be fully done. It is detailed what must be included. The programs, we talk about the programs and the exceedingly importance of a proper schedule. Certainly all the documents that make up the programs, right? But it is supposed to be detailed at the outset because it is supposed to be to aid in identify the changes and the delays early out, updating of the schedule, all of those things are required. I know sometimes as somebody who would have been part of the project management outfits, we tend to be lenient. Government tend to be lenient, and the culture, I think, came about because the experience that people have, and that's how cultures are formed anyway, out of experience. So you have an experience where if you are stickler for all of the documentation, etc., etc., even your own people look down and say, how I doing? And that has created, I believe, the culture that you see that exists now, certainly on the government side. I'm not sure what has caused it on the private sector side or the contractor side. The variations, again, which I'll go into a little bit, the process is much more detailed. Clearer bases are provided for the evaluation, and especially when you're using the schedule of rates. Advance warning, the provision is actually clearer that it must be given, right? Concurrent delays are now addressed in this document. One critical one is engineers' independence. And of course, back in the 80 odd edition, the engineer was supposed to be independent. But then come 1999, the engineer became the employer's representative. And of course, from that time, there was a lot of consternation out there, certainly on the contractor's part internationally. And so FIDIC has moved actually to reel it back in. So they're now focusing on the neutrality of the engineer as an arbitrator of the contract rather than just acting for the engineer. And so it brings up some issues now about the use of, in my mind, the use of the engineer who designed the project as the engineer managing the contract. Some amount of issues there, and so we need to really think about that quite a bit. In the presentation, I'll just note that one of the parties to the contract is the one above, God, because God, them say, is responsible for force majeure mainly, right? Well, that is what them say, right? Force majeure issues. And so they have actually, they now use a term, exceptional events, in the contract, which has cleaned up quite a bit. Some people don't even understand what force majeure mean anyway. Notices, and this is where almost all the actions, if you have a problem under the contract, requires that notice be given. You can't just expect that, a drawing missing. I don't have this drawing. Employer, give me the drawing. You need to go through your documentation. This is on the contractor side. Identify what will prevent you from executing the job and provide notice if you have issues so to do, right? So it must be written. It actually identifies the means of communication as well and notes that emails may no longer be considered valid, right? Is that is deemed an informal method. So, of course, in your particular conditions, you can make modifications to those kinds of things. And the general requirements for the engineer's action, sometimes you see where the engineer ought to do things in a reasonable time. They have sought now to put the engineer under the gun as well, and that action must be taken within, and they define what the reasonable is. All right, so going back, the area of focus, FIDIC 1999, looking at the subcontractors, variations, fluctuation, time extension, and damages. So I saw this someplace, the golden principles, FIDIC, promotes cooperation and trust between the parties. It does not support any party taking undue advantage of its bargaining powers. And that's why you see some of the changes made here. Of course, they always say the engineers tend to try to take advantage of them being the engineer, bully everybody. I don't share that. I'm an engineer. I don't share that kind of concern. It discourages adversarial attitudes and encourages dispute avoidance. And if we actually practice this, it goes a far way in reducing that 90% of contracts that end up in court because of dispute over delays. And it encourages timely and adequate payment in accordance with the contract to maintain cash flow. And it is something that I suppose on the government side, we clearly will need to pay more attention to. Some important tenets, the parties, as I mentioned, employer, engineer, contractor, governments, because these action, and of course, God, nature, right? Because they can act to get some changes in your contract. Time is of the essence. And now actions are time bound. You must act. Many times we have, and I'll say from an engineering, boy, the engineering details missing. And badger the engineer, call the engineer, go. Just talk to the contractors and they'll give you a lot of stories, right? The triple constraints of project management, cost, time, and quality. If you push one, the bulge come out in the other two, or somewhere in there, right? So remember, anytime you change anything on one side, it is going to affect one of the other sides. And we spoke about that the time you give for the project must be reasonable. Dispute avoidance does not mean inaction. A lot of times we try, we don't want, we don't want no issues, So you just kind of avoid the things. And even in your own personal relationships, you know that. To just try to avoid the thing by doing nothing is not a good practice. And certainly not a good practice for contracts. And the written record trumps memory every single time. Even though Jackie spoke about you can enter into verbal contracts, believe me, when it write down, it is much more important. All right, so into the subcontractors now. The contractor, and everybody know this one, shall not subcontract the whole of the works. Now, I don't see it happening much in recent times, but I must tell you, there was a time with the PPC, with the NCC being in place, and contractors will enter supposedly into agreement, but it's really not them doing the work. It's one other contractor who couldn't get registered for one reason or the next, right? People probably won't agree that this happens, but you agree? All right, all right. So that in fact is subcontracting the whole of the work, and that is actually illegal. You then would be in breach of the contract. And the contractor, once he has a subcontractor, is responsible for the acts or the defaults of said subcontractor. Conditions for subcontracting of works, the engineer's approval is absolutely required. Must get the approval. And before the subcontractor start the work, you must give notice to the engineer that the contractor will start the work. And the time for that is within 28 days. And the The contract, when you enter into subcontracts, you must have a provision to assign said subcontract to the employer in the event that we fire you as the employer. So in the event that there are issues and you have to be terminated, the employer should be able to continue the execution of the work using said subcontractor. Of course, then there are nominated subcontractors, and this is normally stated in the contract, but in general is instructed by the engineer, right? Contractor can object because sometimes you look at the subcontractor and usually you don't object to the one that is stated in the contract because you would have objected during your tender process. And I know of one contractor who has actually done this as a part of the responses, asking questions during the tender process. So it can be done at that time. But once the contract is in place, you may object. Of course, you have to give reasons. You're not just objecting out of the blue. And questions really about the capabilities of said subcontractor to undertake the work. That is mainly where the issues are. I suppose if you have personal issues, you can work together. I don't know whose hand you have to squeeze to sort that out, but that's kind of outside of formal reasons. The contractor can object if you are not providing indemnity against whatever actions that subcontractor might do, and a clause is not in place for that subcontractor to be obligated to the contractor for which he is subbing. All right? If no objection, if you just accept it and move on, the contractor is responsible for the work. It has to be formal for him to say, listen, I'm not going to be responsible for the work of the subcontractor. Of course, you have to ensure the engineer can request information to ensure that the subcontractor is being paid. And if not, then the engineer can pay usually the employer, can pay the subcontractor and take it out of your money. All right, so we move on to variations. And we start, of course, with the right to vary. Is that the employer, having let the contract, is given the right to vary said contract. Because issue may come up during the execution that requires modifications to the contract. And so, again, the engineer shall instruct, right? And this instruction can come anytime before the issuing of that taking over certificate. So all the way down to almost at the end. Now, when you hear out there in the public that, boy, the contractor, them just like variation, it is not a contractor issue. It is an employer issue, full stop. Once the variation is issued, it becomes binding on the contractor, right? Unless, of course, he gives notice that he can't do it. For example, you want a particular type of tile instead of the terrazzo that was in there. You want a particular type. The contractor check him can't get it. He might say, listen, I can't undertake this variation. And so when he does that, the engineer should review whatever the instruction is, can cancel it, change it to something else, or say, listen, I know that it exists. You go ahead and get it. And the variation can include changes in quantities, quality, other characteristic, the level of whatever it is that you're building, where you're putting things, the dimension of things. All of those things can, in fact, be varied. Can include omission of work as well, and additional work. Usually work that is necessary for the permanent works. Right? Don't go down the street there and go build a little, Miss Matty house under this contract. That won't work. Value engineering, again, this one now is contractor initiated. So the contractor, and we've had this happen, the contractor, having received the contract, looks at some of the things that are to be done and make a recommendation that, listen, I can save this project $20. Of course, it has to be substantial, so depends on which currency you're using. So $20. And the engineer look at it and say, yeah, this sounds reasonable. Have discussions with the employer and ask the contractor to submit a proposal. Of course, the benefit must be time related, and everything quality, as I say, quality, time, and costs are interlinked. So it must affect one of those, including the life cycle cost of the project. Again, a written proposal is required. You can't meet him out at the bar and say, you know what, I've heard the contract. It's not like that. It must be in writing, must be properly documented. The contractor will then be responsible for the designs related to that, although it is the engineer who must accept and then issue the variation. Savings, so this is the one time that the contractor can get involved in the process, but it is the engineer who must issue the variation. And of course, the savings, FIDIC recommends that it be split 50-50. And I suppose that's substantial savings, right? So for the procedures generally, engineer shall instruct, or you can request a proposal from if you, and the employer knows exactly what you want, you can then instruct it straight up. If you're not so sure, you say, boy, contractor, I wanted to look at this for me and give me a proposal for it. It can be done like that as well. All right? Again, the contractor is to respond within 28 days with the description of the work, the method to be used, the execution program, the impact on completion, any cost or EOT implication. Provisional sums. Now, this is a money that is put in there because I want to do something, but for whatever reason, it has not yet been detailed. And so a proper estimate of what it is that you wish to do ought to be provided as provisional sum. It shouldn't be just a money. It should be a good educated guess, as they call it. So that work is not identified in the contract, right? And so the contract, once that is agreed, once you know what you want to do, a variation has to be issued for that. And the contract price will be adjusted based on the actual cost to the contractor plus profit and overheads. And usually these are stated in the contract. Day work. A lot of people say, what is this day work thing? So this is a listing of cost. The daily cost for your resources, material, labor, equipment, and so on, that is a part of the contract, appended to the contract, a rate sheet, and you can use that to do minor work. Again, it's a variation issued, and the payment, the cost of it is based on these rates. Change in legislation. Again, this is where governments, not government, governments come in. The effective date is the base date of the contract, and that is sometime before you actually submit the tender. Once the legislative changes affect the ability of the contractor to perform, cost more money or so on and so forth, then the contractor can make a claim. And just to know, it is applicable for permits, license, all that. You might hear say, boy, you have to get another license. You can't just go on site. If you go in, you had a contract now in Catherine Hall. You might, government might quickly say, listen, I need to relook at the developments in this area, and therefore I will not issue any permit for the time being. That would then be something that the contractor could claim for. And just to note that it could also save your costs. I mean, and if the changes end up saving the contract money, then the employer can benefit from that as well. And then this one, and we have always had this issue about variation. Is fluctuation a variation? You know, this is a discussion in respect of the public at large. When you hear say, boy, variation and it caused the price to move by so and so and so. And the public sector talking all the time is not variation, not change. Is the price of the cement gone up? It is the price of the lumber gone up, etc., etc., etc. So the fluctuation is actually part of the adjustments under this clause. Of course, it requires predefined schedule of costs, and usually if you want to use a formula, an applicable formula for how you use those costs. If there is no schedule of costs, if you don't include that material or that piece of whatever labor, some labor costs or whatever in that schedule, you are not a submission for fluctuation for that item would not be valid. And this actually, the schedule should reflect market conditions. A lot of times, and in the Jamaican context, what we have done is to have the contractor just put the tenderer, I shouldn't say contractor because it's not yet the contract, puts all of these prices there and nobody checks them. And then when time come now to implement, you say, but you have in there that you are going to buy a bag of cement for $2. But we know say from long time that this bag of cement from thing is $25. And now it's 27, so you are claim for $25 on the $27 bag of cement. When the movement in the market over the time was only $2. And this is something that has happened over and over and over again. And the engineers is part of the, whoever is the engineer on the project to ensure, and FIDIC allows for you to make modifications to this document until everybody is satisfied with what is in it. All right? So the essence of it is to protect the contractor from the effects of inflation or sudden market changes, like war in Ukraine causing certain material prices to spike, and seek to ensure that the employer only pays for real market-driven increases. That is the objective, and that is what all the parties should ensure occurs. Cooperation, again, so the employer, we spoke about, I think one of the presenters spoke about it, can have, the contractor allow people to come on site and do some work. Usually they try to say, put it in the contract and identify the person as a subcontractor. But whatever work that is being done that would have an impact on the contractor's costs, if the contractor would not have been aware of the need for that and being able to put it in his cost, could constitute a variation. Time extension, and this is where most of the between the variation and time extension, cost and time, the two issues. I spoke earlier about commencement of work. The engineer shall give no less than 7 days notice to start the work. And the start date should be within 42 days after you issue the letter of acceptance. And the contractor is required, because the clock starts, the contractor then is required to promptly proceed with due expedition and without delay. Time for completion. The contractor shall complete the work in accordance with the time for completion. As I say, it ought to be reasonable, and so later on you'll see that coming out. And at the time for completion, we include achieving the passing of the tests on completion, and it must cover all the work that have been stated as being required for that completion. And then we get to the program. The contractor shall submit detailed time program within 28 days after receiving notice of the commencement date. I know that there's also an issue there that he could have commenced, but not yet submitted the program, which is fine, right? So it assumes the project is long enough to sort out those things, right? The program to include the order of works, including the estimated time of the various stages, including if you have to complete something for whatever reason prior to other things. The submission of the documents, the identification of the procurement of major items, including when these items are expected to be delivered on site, and general construction, erection, and testing. And that program ought to include a general description of the methods to be adopted, right? So how you going to do the work, which is, you'll see that as soon as you do that, it will then tell you if you have an issue with the date that has been set. Major stages in the execution of the work, details of each class of contractors, personnel, and equipment required on site for each stage. Now that the engineer does not approve this program, what he does is, or she, is check for compliance, and if there is an issue, get it back to the contractor for any changes to be made. And the contractor then is required to proceed in accordance with the program. Just to note that because the employer and his personnel will be doing stuff relating usually to the work, it is important that this be accurate because the employer's personnel is entitled to rely on the program when planning their own activities. The contractor shall promptly give notice of specific probable future events which may adversely affect the work. So if something is happening that you say, and we spoke about it earlier, that this is going to cause me a problem down the road, you are required to give notice as soon as you become aware of whatever the issues, within a certain time of you becoming aware. So you having done that, the engineer can, well, it says may give notice. So if the engineer receiving the report on the program, reviewing the program on a monthly basis or every 2 weeks, identifies that, listen, the contractor, you're falling behind, then the engineer will give notice to the contractor to say, listen, I need an adjustment made to the program to be consistent with your actual progress and to show me how you're going to then get back on track. The contractor shall be entitled to extension of time if variation issued or substantial increase in quantities occur on the site. So if you had to do, the BQ had a certain amount of excavated mall, soft spots, whatever it is, then if this increases, a variation is to be issued and the contractor is although I have remeasured work, so it depends on the quantity of whatever the thing is in the first place. Exceptionally adverse climate conditions, and remember, this is exceptionally adverse. The information for this, usually the background information and the supporting documentation, would be information from the Met Office. Unforeseeable shortage in personnel and goods caused by COVID-19, right? This was a big issue in 2022 and so on, when initially I think the feeling was that this is outside of our action, and therefore no additional time is due or whatever it is. So, but that has been sorted out because government say the construction industry never closed down. All right? Any delay caused by the employer or the employer's connections, your representatives, the engineer, etc., etc. delays caused by the authorities as well. So the authorities can prevent things from happening and create a problem here. Force majeure, there delayed drawings or instructions. Same thing here, we spoke about this. If the engineer does not provide the necessary drawings or instructions, it is then for the contractor to indicate how it has affected him or affected the project and to make a claim which the said engineer is going to be administering. And so this is where you may have some amount of issues which we have to address. The EOT and cost not applicable, and this is important, if the engineer's failure is due to the contractor's either error or delay in the submission of any of the contractor's documentation, right? So if it is linked to that, generally the submission request will fail. Right to access to the site, the employer shall give the contractor access to and possession of all parts of the site within the time specified or consistent with the program, right? Of course, you may withhold the approval if the performance security, which is part of the documentation required, is not submitted, all right? So setting out, same thing, when we spoke about it earlier, that the contractor, I think Woodrow spoke about it in the CIC, is that the contractor is responsible for setting out the work, but if there are errors identified in the setting out data, then it becomes the employer's responsibility, and the employer should correct and so on and so forth. But again, notices and all of those things come into play, and also it requires that the contractor, an assessment be done to see if an experienced contractor ought to have been able to identify this thing long time and so not have it have an impact on he or she on the project. Unforeseeable physical conditions, this include natural, man-made condition, pollution, asbestos found here, subsurface, water running under the thing. I guess down a country there were water rising in the place. All of these things, if you didn't foresee them, you can make an application for time adjustments. But the contractor, even though he has submitted a request, must continue to do the work. The engineer, in doing the assessment, the investigation, could identify favorable conditions, right? And then this must be taken into account when assessing cost or extension of time. Of course, for time extension in general, the claims are to be made in accordance with clause 20.1. Once you give a EOT, you can't take it back, right? Once given, even if the contractor then is responsible for further delays, it is what it is. That is netted off at the end. The list of items that are applicable for time extension ought to be exhaustive in the contract. Don't put a sweeper clause or any other things that may happen that will lead you into problems and no doubt into court. Of course, notice is always required, and notice is required because it allows for the employer to say, listen, I'm going to change something. I'm going to change or do this. Or for the engineer to quickly respond with the drawings or whatever it is. But notice on when you will be impacted allows for the mitigation of whatever the problem is. Damages, just quickly now, have 1 minute. Employers claim, performance security, rate of progress, delay, damages. For the employer can claim as well that the contractor's action is affecting him, causing money, quite apart from time. Notice to be given as soon as whatever the event is occurs. Basis of claim to be specified and substantiated, similarly to what the contractor must do. with both time and cost, and is subject to determination by the engineer. Performance security, valid and enforceable until the work is completed and defects corrected all the way through, right? And it can be claimed if the contractor failed to extend the validity, pay amounts determined or agreed, fail to remedy a default within the prescribed time. And just note it can be claimed under circumstances which entitles the employer to terminate the contract. And there's a long list of those. The rate of progress, the engineer has the authority to instruct the contractor to submit a revised program with the methodology about how they're going to keep up with the progress, and then they are liable for any related costs, including those of the employer. The rate of progress and delay damages, if progress too slow, spoke about that. Failure to comply with the time for completion, then we can call your bond, we can then apply liquidated damages. This is normally in the contract with the maximum amount identified. It does not, however, relieve the contractor of the duties and obligations under the contract. And that is it. I think I just hit on the 5 minutes. So I thank you. Thank you for listening.
How do you rate the current construction industry? Do we think that it is providing a service for the growth in the country? Or do you think that we need to recalibrate, reset to try and ensure that we attract the kind of investment we need into the construction sector to ensure growth in the economy generally? And let me just put a little thing out there. If I was sitting as an investor not involved in the construction sector, and after the discussion, especially contract administration, it is better for me to go start a car sales thing and bring in cars and make 40% on my money, rather than go through all of this and at the end of the day project probably 10% and don't end up with more than 5 if I end up out of bankruptcy anyway. So the question really is, what do we need to do as an industry? For example, I hear you speak a lot about the fluctuation and the variations in terms of costs. In other jurisdictions that I have worked in, there is an index, construction price index, that is issued every month, right? That deals with labor, deals with materials, it deals with regions. As in South Africa, it's a different one you get in Johannesburg from Durban, right? So you relieve the contractor of some of this bureaucracy and this potential dispute by virtue of the industry and the environment creating a scenario where it is easier to do construction and to attract the kind of investment. Because I'm sure most of the foreign investors and the foreign contractors who come here are not subject to this. And therefore, my lasting question and what I'm really hoping to go away with in terms of some hope, that we recognize the inefficiencies within the contracting fraternity, within the client fraternity, and how do we fix that to increase productivity and make construction more profitable and less risky?
That actually is a kind of political question because it has to do with government policy in general, and it's something that the IMAJ is well set up to address. And in fact, I think it is something that, a lot of times it's the same people do things all the time. It's the same man you want something fixed, but it's the same man you have to call on. It requires the construction industry to get together properly a commitment that they themselves will ensure that they do the things right and approach government with policy modifications in this regard. All right, and I think it can be done, and it should be done, by the way.
The construction industry accounts for approximately 8% of the GDP of the country. It's not an amount that one should sneeze at. We looked at the PPC and it spoke about 154 billion. So it's quite a bit of money. What tends to happen here is that I think the two things. I think we tend to underrate the professionalism that we have in Jamaica. And we don't realize that we have persons who are capable of pushing the industry forward. And I also think that we need to cooperate with each other to get things done. The new construction industry policy is being put together by a group. And if we can get an opportunity to have an input into it, and this is going to go through the Construction Industry Council. A lot of persons don't know that there's a Construction Industry Council, but I'm hoping, probably it won't benefit me, but for the youngsters from Heart and those who are coming in, it's going to be absolutely important that you encourage and you take part in the industry you choose to make your career. It can be a profitable industry, but if you abuse it, if you're only in it because of the money that you think you're getting now, in the long run, it's not going to get any better. But it does offer an excellent opportunity to move forward. One of the things I would want to propose is that for every construction company who comes to Jamaica to set up and to do construction, they should be asked to include at least 10 or 15% of local professionals and employers so that there can be transfer of technology and professionalism. Every other country who does that sees their own grow. We don't have that. I know some of the Chinese do take on a few laborers at one particular end, but at another end, they operate and at a different end. But I think one of the policies you should push forward for everybody who comes here to invest, they should know, if you come into Jamaica, 10% of your labor force from top to bottom is going to be Jamaicans. That is one way to do it.
Afternoon, ladies and gentlemen, esteemed colleagues, partners in the construction industry. As we bring this important seminar, to a close, it is my privilege to extend the association's gratitude. First, our sincere thanks to the Honorable Robert Nestor Morgan, Minister without Portfolio in the Ministry of Economic Growth and Job Creation. I'd like to thank him for his opening remarks and his ongoing support for the sector. To our President, Mr. Richard Mullins, thank you for your leadership, your guidance, and your commitment to advancing this association. Your vision continues to drive the growth and relevance of the IMAJ. A special thank you to our gold sponsor, the National Housing Trust. I don't know if anybody is here from them. We also express appreciation to all our other sponsors, Berger, IMCA, General Accident, CG United, CMEX, Delta Supply, Tankweld, Isratec, National Supply, H&L Homes, JN Bank. Those are all sponsors, silver and bronze. Your support is what enables the IMAJ to deliver impactful events such as this one. To our presenters, thank you for sharing your expertise with such clarity and commitment. Our moderators, thank you for guiding each session and keeping discussions organized and engaging. To our participants, your engagements, your questions, and your willingness to sharpen your professional skills affirm exactly why the IMAJ continues to be a pillar of leadership in this industry. It is this participation that strengthens our mission and drives the industry forward. To our seminar chair, Mr. Paul Williams, thank you for stewarding today's program. Special appreciation to the IMAJ Secretariat, the technical team, and the support staff. Your work behind the scenes ensure the smooth flow of the day. Thank you, Ms. Scott. We also extend thanks to the Jamaica Conference Center for hosting us today and not kicking us out as we go over time. Today, we have explored a topic that is too often overlooked, yet fundamentally shapes every project we undertake: the power and purpose of contract documents. We have examined not just the clauses and conditions, but the deeper truth that professionalism brings, that professionalism begins long before materials even reach on the site. It begins with understanding our rights, our responsibilities, and the frameworks that govern the business of construction. In other words, the business of construction is not only about equipment, manpower, and timelines. It is fundamentally about the contract. Mastering contract documents is not just paperwork, it's empowerment. It is the knowledge that protects your business, strengthens your competitiveness, builds your credibility, and positions you to lead in an increasingly demanding marketplace. As we have discussed throughout the day, this knowledge is not only beneficial for you as individual professionals, it is essential for Jamaica. In the wake of Hurricane Melissa, our nation is dependent on the competence, readiness, and professionalism of its local construction sector. The scale of rebuilding ahead requires professionals who are not only skilled with tools and materials, but who are also strong in management, documentation, compliance, and accountability. The work, the work of recovery will be complex. It will require coordination, discipline, and resilience. But today's seminar reinforces something we have always known here and said here at the IMAJ. Jamaicans are capable, Jamaicans are prepared, and Jamaicans are essential. As an association, IMAJ remains steadfast in our advocacy for the local capacity, fair opportunities, transparency, efficient procurement, and strong institutions. But no policy, no reform, no national plan can succeed without professionals who take responsibility for continuous growth. And by being here today, each of you has demonstrated that you are committed to rising to that challenge. So as we leave here today, let us do so with a renewed focus. Let us leave with a deeper understanding of our craft, not just the physical construction of buildings, but the intellectual construction of businesses. Let us leave ready to build with confidence, to negotiate with clarity, to document with precision, and to perform with excellence. Most importantly, let us leave united in purpose to rebuild, restore, and strengthen Jamaica, one contract, one project, one community at a time. On behalf of the IMAJ, thank you for your participation, your professionalism, and your ongoing dedication to elevating this industry. May the knowledge gained today guide your decisions, expand your opportunities, propel your business to even greater success. As we close, let us carry with us this one thing with us. In construction, buildings rise from concrete and steel, but our industry rises from knowledge. The more we understand our contracts, the stronger and more successful Jamaica's construction sector becomes. Let us go forward and build not only structures, but a smarter, more united industry for the future. So safe travels, continued growth. Let us move forward together, stronger, wiser, and ready for the work ahead. Thank you.